iniciamos a continuación la agenda académica con la ponencia Vigilancia y Control de la Publicidad de la FTC, Federal Trade Commission, a cargo de la doctora Lesley Fair.
Gracias. It's an honor to speak to you today. I was going to open with a brief introduction to the work of the Federal Trade Commission, but the superintendent has already explained that. Our job is to enforce, to sanction, to inform, and to educate, which is why we consider ourselves brothers and sisters with SIC in the important work that they do. The superintendent has also taught me a new word this morning, debogotization. My job at the FTC, I guess I could say, is de-Washingtonization. Our job is to make sure that we reach America's 300 million plus consumers, to make sure that they have the information they need to make wise purchase decisions. And like the three distinguished speakers that you heard from this morning, we think that's not just in consumers' interests, that's in business interests too. A major American department store has as its slogan, "An educated consumer is our best customer." I wish I could say that the Federal Trade Commission got that slogan first, but we really do believe that education and information for consumers and businesses is what leads to the healthiest economic system. I'm going to talk just briefly a little bit about the different offices at the FTC, just to put in context our work when it comes to advertising. The Bureau of Consumer Protection is the part of the FTC that I work for. We have a division of advertising practices that deals with major national advertisers, food companies, over-the-counter drug companies, for example. Our division of financial practices has important roles with regard to credit. However, as many of you know, in the United States, we have a brand new agency, the Consumer Financial Protection Bureau, and we're working closely to We're working closely to handle jurisdictional issues there. Our division of marketing practices handles primarily now hardcore fraud, often online, internet fraud. We think global commerce through the internet is a fantastic phenomenon. The idea that I can buy a pair of shoes from a company in Australia makes me very happy. But we want to make sure that consumer rights apply across the board in a global context, which is why we work together so closely with our international counterparts. Our Division of Privacy and Identity Protection is our newest office and performs much of the same work as the Data Security and Data Protection Office here in Columbia. Our Division of Enforcement very often handles that small group of companies that have violated the law more than once. We think they deserve special attention when it comes to enforcing, sanctioning, informing, and educating. And so that's what that office does. Our Division of Planning and Information, Our Division of Planning and Information handles our very popular National Do Not Call Registry. We have more than 250 million telephones signed up on that registry that prevents companies from calling consumers who have made it their intention not to be called at home. And a lot of consumers are very grateful for that. They also handle the more than 15,000 complaints we receive every week from consumers. They handle our toll-free telephone number, so they have a very busy job. Finally, our Office of Consumer and Business Education, well, we have a lot to learn from the SIC. I've seen the wonderful graphics and educational materials that the SIC produces to reach out to consumers and business. I guess to say that I plan to steal their ideas may not be the nicest thing to say. Don't tell them, but their materials are so informative and so educational, I certainly plan to. When it comes to the legal process, certainly the FTC does have a small number of regulations dealing with specific transactions. when consumers buy a used car, when consumers buy funeral services, when consumers buy appliances. Oh, there, why this is jumping ahead. Not yet. When consumers buy appliances, there are specific labeling requirements. I like to say that every American has something right behind his or her neck to remind him of the FTC, since we handle those labels in all clothing that tell consumers how to clean the materials, where the materials are from. That said, you'll have to take it from me, I do not have a tattoo. However, if I did, here's what mine would say. Unfair methods of competition or unfair or deceptive acts or practices in or affecting commerce are hereby declared unlawful. That is the statute that I have been enforcing for 27 years. That statute will celebrate its 100th birthday in September of this year. So this is a very important year for the FTC. The first 4 words, unfair methods of competition, deal with my colleagues who handle antitrust and anti-monopoly law. I will not talk about what they are doing, but I will focus on the advertising part of the statute. That is the phrase unfair or deceptive acts or practices. Under our statute, a practice is deceptive if it is likely to mislead consumers who are acting reasonably under the circumstances, and if it would be important material to their decision to buy or use a product. That makes up about 95% of our work. A practice is unfair, or an advertisement is unfair, if it's likely to cause substantial injury. Now that could be physical injury, that could be financial injury or otherwise. That's not reasonably avoidable by consumers themselves, and that would not outweigh benefits to consumers or competition. For all of us who have had to take a economics class in school, you will recognize that as a classic cost-benefit analysis. So that unfairness jurisdiction is about 10, maybe 5 to 10% of what the FTC does. The same standards apply across the board, regardless of the nature of the product. So a law student called me recently and said, the FTC, I've researched it, the FTC does not have a law about mobile apps. And I said, yes, we do. We wrote it 100 years ago. Unfair or deceptive acts or practices are hereby declared unlawful. So it applies to all companies. It also applies regardless of the medium, whether companies advertise online, on television, on radio, through direct mail, the same standards apply. Now, there are some things that our statute does not cover. Most importantly, it does not cover questions about taste or propriety or ads that some consumers might find offensive. When individuals call to complain to us about that, my first response is, you, American consumer, have the strongest tool against that. If a company's ads offend you, do not buy that company's products and contact them to let them know you're not going to. That, in many ways, as any entrepreneur will know, is more powerful than any government sanction in this area. We also don't cover certain classes of advertising that Congress in the United States has told us we do not have jurisdiction over. We do not have jurisdiction over insurance, for example, most banking or securities activities, most mortgages, things like that. But the typical consumer products, consumers, cars, food, over-the-counter drugs, vitamins, toys, all of those things do fall within the FTC's jurisdiction. Under our statute, we do not have the authority to fine companies that violate the law. So unlike many of your countries that do have fining authority, we do not. Certainly we can get an injunction against a company. And if a company violates an injunction, then we can go to court to seek a fine. But only a federal judge can issue that fine, and that is a judge that has no connection to the Federal Trade Commission. The other thing, we can, on occasion, ban an individual from an industry. What we can do, however, is get refunds for consumers in appropriate cases. So the maximum refund we can get is what the consumer paid for the product, however. We can also get informational remedies, labels or warnings for consumers in the future that companies must put on their products. One famous case that we brought involving refunds for consumers was a famous American, Miss Cleo, the infomercial psychic. Miss Cleo claimed to be able to offer advice on your love life, on your financial life, and for only $3.99 a minute. Many consumers called up. Now, interestingly, we did not sue Miss Cleo for not being a psychic. I like that consumers have a right to make, to buy foolish things. I like that too. However, the concern in this case was that the company was advertising $3.99 a minute, yet charging consumers much more. So we sued the company that advertised Miss Cleo, the infomercial psychic, and were able to return to consumers more than $500 million. Now, some people said if she was that good a psychic, she would have known we were going to sue her. I guess that says something about what kind of psychic Miss Cleo was. Just the few basics about advertising law I hope to impart. Under the FTC statute, companies must have, they're responsible for all claims, express claims and implied claims that consumers take from the ad. And by that we mean we look at the net impression that an ad conveys to consumers. It is not a legal defense for a business to focus just on the literal meaning of the words. We look at everything: the colors, the pictures, the fine print, the images. That's what we call net impression. Speaking of fine print will not cure an otherwise deceptive ad. And about 5 years ago, when I started to have to put on these glasses to read the fine print, that's when this became even more important to me. But fine print does not cure a deceptive ad under our statute. And finally, the advertisers must have what we call competent and reliable evidence to support all objective product claims. Now, we're going to have an excellent panel later today about puffery. So our statute does not cover puffery. World's best cake is not a standard that the FTC would sue about. Most delicious chocolate is not something that the FTC would take action about. But if the company makes objective product claims, then we will. I'd like to show you just a few examples illustrating that principle, and then get to really what I think is of most interest to all of us, which is what's on the horizon in advertising. What's the future look like, and where is the FTC seeing what we're going to do in our country about those issues? Here's a very simple ad. This was a catalog claim for the Neiman Marcus company, a very popular American department store. They advertised a beautiful coat with a false fur collar. They advertised false fur made of polyester viscous collar. But there was a problem with the false fur collar. According to the FTC, it was made of real fur. Now, for many consumers, they don't want to buy or wear fur. That's their personal choice. They can buy fur, they cannot buy fur. But if a company says something isn't fur and it is, or if companies say something is fur and it isn't, We look at that as an express misrepresentation that we can sue over on behalf of consumers. Now, I talk about this net impression and how important visuals are. All of us in this room work closely with the advertising business, what creative people they are, and how effective they are in conveying claims both through words as well as through pictures. Here's an example of a case the FTC recently settled. It was a video that appeared to be something that a young person made with, and posted on YouTube from their smartphone. It kind of moved around a little bit, and it showed a dune buggy stuck on a sand dune. And with a number of young men in sports clothes saying, "Yo, dude, hey, brother," kind of talking among themselves, because the car was stuck. And then all of a sudden, a Nissan truck came up the sand dune and pushed the dune buggy to the very top. And they all went, "Yay, dude," and lots of thumbs up and lots of high five. The concern that the FTC had in this case was that the visual did not accurately reflect what the product would do in real life. In fact, the ad was made by using cranes and chains to put those cars on that sand dune, and the truck really couldn't push the dune buggy up the sand dune. In fact, we alleged that the camera angle was slanted to make it look like it could do something that it could not do. That's why the FTC settled a lawsuit both with Nissan and with Nissan's advertising agency. Because under our statute, not only is the advertiser liable for misrepresentations, but in certain instances, if the advertising agency knew or should have known that the ad was deceptive, the FTC may also take action against the advertising agency. I mentioned the issue of fine print. A lot of FTC cases involve fine print. The way I like to word it is what the headline giveth, the footnote cannot taketh away. In the United States, we'll see a lot of ads that say, "Lose 30 pounds in 30 days, no diet or exercise required." And then in tiny print at the bottom, "diet and exercise required." That's not a defense. Here's a very interesting ad that appeared in a magazine. It's also interesting because I did not add the Spanish language in this. This was an ad that appeared interspersed Spanish and English. This was a car advertisement put out by a used car dealer. You'll see the car advertised in the red circle, and then, you'll see fine print down at the bottom. What the ad offered, or claimed to offer, was a Chevy SUV for $17,995. Okay. Then here's what the fine print said. It was $17,995 after the consumer had already paid $5,000 down payment. So under our law, that was deceptive. It should have been advertised as a $22,995 car, not a $17,000 car plus $5,000. Now the company's defense was, "But we said it in the fine print." The FTC's response is, fine print cannot cure deception. So we've brought numerous cases dealing with fine print, but the corollary of that is what we call the buried hyperlink. How often online have you seen little buttons that say things like "more information," or my favorite, "legal"? I don't think I think the only people who click on those buttons are FTC attorneys investigating a case. Maybe I'm exaggerating, but our concern is burying important information in hyperlinks on web pages is not a defense under the FTC Act. So that's just an example of when I'm talking about fine print. Here is how that happens in an online setting. The major retailer Sears Kmart offered consumers a way to be involved, to have a line of communication to talk about products and services. And Kmart offered them, I think, about $10 to join what they called their community, their My SHC community. So to sign up for the community, consumers clicked yes. They then got taken to this page, and 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 this page. Here's what it said on the 75th line. Once you install our app, it monitors all of the internet behavior on that computer, even secure sessions, for example, banking or things like that. The FTC said that that information was illegally buried in that long legal disclaimer. And that if information is important for a consumer to have in advance, that information has to be explained upfront and can't be buried like that. I'm curious who other than a lawyer would have spotted that on the 75th line. Here's what our legal standard is. If the disclosure of information is necessary to prevent an ad from being deceptive, the disclosure must be what we call clear and conspicuous. Many companies and lawyers call me all the time asking me, is it 1 inch? Is it 10 centimeters? Should it be Times Roman font? Should it be Helvetica font? We suggest taking a step back because we are not in the business at the FTC of mandating what ads look like. Who knows better than an advertiser how to make information clear to consumers? They're the experts. So what we do at the FTC instead, generally speaking, is mandate what we call a performance standard. And we evaluate disclosures by 4 standards. First, prominence. Is it big enough so consumers are going to see it? Placement. Is it where consumers will even look? Proximity. Is it close to the claim that it relates to? And presentation. Is it worded in a way that reasonable consumers will understand? Not with fancy legal talk, not with complicated jargon. Is it worded in a plain, clear way? That's the standard we apply in looking at fine print advertising. The final just basic standard I wanted to touch on very briefly is the standard of substantiation. Under our law, companies must have, before they disseminate an ad, objective proof that establishes the truth of every objective claim they make. It's not enough to come up with the information after the FTC comes knocking on the door. Companies must have it in hand beforehand, and certainly I know the American attorneys in the audience today are familiar with working with clients on that standard. Here's just one example that certainly when the claim is about health, safety, or product efficacy, it's not just competent and reliable evidence, it's competent and reliable scientific evidence. Here's a very popular ad in the United States. This was for a product called Sensa. It said you could sprinkle it on your food and cause you to lose weight. The claim was, Sensa is clinically proven to help you lose 30 pounds without dieting. Sprinkle it on your food, eat, and lose weight. I wish that were true. But our scientists said it was not. The result in this case was a legal settlement for $26 million. Now, it's important for me to mention where that money goes. Under our statute, all of it must return to consumers who bought the product. Now, that's easy or easier for online sales because the company knows exactly who their customer is. It's much more difficult for products that are also available on retail shelves. We struggle with how to spread the word to consumers that refunds are available. We use meetings like this and other conversations with international counterparts to find out how they do it, to learn from them how to get the word out for consumers. One look at the SIC website explains why they received a major prize, because they have a website that is clear, that's easy for consumers to use. As I said, we have a lot to learn about getting the word to consumers. But that's an example of a competent, reliable, scientific evidence that the FTC said the company did not have. Another major area where science comes in is in the marketing of products with environmental benefits. For an awful lot of consumers, they want to know, is a product recyclable? Is it made with sustainable means? Is it a better choice for the environment? Here's an example of a paper plate that was advertised by saying it was, among other things, biodegradable. Now, it's true, if you use the paper plate and left it out on your front lawn, the wind and the air and the rain would ultimately cause it to biodegrade. In the United States, at least, most people will take their paper plates, put them in a plastic bag, throw them in the trash, and that winds up in a landfill. I'm not a scientist. I think I am exaggerating when I say that things in landfills never biodegrade. That's not true. But it's certainly going to take hundreds and hundreds of years. So we alleged that the company who manufactured and sold this product was deceptively saying that the product was biodegradable. Yes, it might biodegrade in a laboratory, but it wasn't able to biodegrade in the way that consumers generally use the product. So we use that as an important standard. How do consumers really use the product? I think the superintendent and others have emphasized the importance of business education, and this is one area where I think we have taken that lesson to heart. The FTC, about in 1993, and revised 4 times since then, have issued what we call our green guides for businesses. This is informal guidance for business about how these terms are defined and how the FTC will interpret these terms. Now, how do the green guides come out? I'm not a scientist. I was a literature major. I know nothing about the science of it. So here's what we do. At the FTC, we will convene a national workshop. We will bring in scientists, consumer groups, independent professors, members of the business community, trade associations. We will all sit down publicly and share ideas about how consumers understand these phrases and what the best policies are. And once we do that, the FTC will take all that information, we will go back, we will come up with a proposed standard. We will then publish the proposed standard, accept another round of comments, and after receiving the word from consumer groups, from scientists, from members of the industry, we will issue our final guidance. It looks a lot like the wiki process. Folks getting together, sharing ideas, and coming up with the best idea. I'd like to think that the FTC has been wikiing for 100 years now, since that's how we come up with what those standards are. Let me shift very briefly to what I see as the horizon issues. at least what comes across my desk, what seems most important to the future of advertising. Certainly one important thing is this notion of scientific substantiation. We are seeing many products advertised these days making health claims. Vitamins, foods, medical devices. It's not just medicine anymore, and we're concerned to make sure that companies have appropriate science. Advertising in social media. Those of you who represent businesses understand how important this issue is for consumers and for businesses. One issue of real interest to us that's related to that is the blurring of the lines between advertising and content. When I was growing up and watching television, I could easily see what was the program and then what was the commercial. What we're noticing in the United States, and I think globally, is a mixing of advertising content and entertainment or news programming. And that's something that we're concerned about and want to talk to businesses and consumers about, and have been doing that. Mobile marketing. Think of how many of us, rather than visiting the shopping mall or the store, our shopper has become our smartphone. That's a wonderful convenience for all of us and for consumers. But there are some risks and concerns to make sure that the consumer protections that apply when consumers visit a store down the street also apply when they are shopping online. So I'll show you a few examples there. And the related issue about consumer privacy and data security. Of course, this is an issue in the non-internet or non-mobile world, but I think we all know that the rise of internet commerce and the rise of mobile marketing has led that to be of even more concern to consumers. Let me show you one tiny example in this scientific substantiation way. When I was growing up, ads for cosmetics would talk about making your skin glow youthfully, would talk about making your eyes pretty. We still see that, but there are other claims that cosmetics companies are making. This is an example of a settlement that the FTC brought against the international cosmetics marketer L'Oreal. The company claimed for a skin cream that genes produce specific proteins. With age, their presence diminishes. Now boost genes' activity and stimulate the production of youth proteins. That to me sounds more like a science book than a skin cream advertisement. But that shows how things have changed. And if that's substantiated, if the company has proof, that's great. But the FTC's allegation in this settled case was that L'Oreal did not have the scientific studies to back up, to support those claims. So our standard is, people will say, well, what are your laws about cosmetics? Are they different from your laws about foods? We don't look at the aisle of the store where consumers buy the product. Our concern was with the claim that the company is making. So that's an example of something we're looking at very closely, is how much more science is coming into advertising claims. And we know why it is, because it is a very persuasive thing for consumers. Let me turn to this interrelated area of advertising in social media and blurring the lines between advertising and content. The FTC issued our endorsement guides. Actually, the endorsement guides have been around since the 1970s, but we revised the endorsement guides in the year 2012 to offer examples related to social media. The law did not change, but rather than talking just about newspapers or magazines, we talked about bloggers and tweeters. The law is the same, the medium is different. The FTC settled a lawsuit with a public relations firm, and this was a very interesting allegation, I thought. The company did public relations for very popular gaming app developers. FTC alleged that the public relations company went on to the iTunes store and posted very favorable 5-star reviews saying, one of the best, amazing new game, great family-friendly board game app, hits another home run with this app, without disclosing that they worked for the company hired to market the app. Now, if my friend tells me, I just got a wonderful app, I think you'll like it, you ought to download it, that's important to me. That's important information. When I go on a site like Amazon or iTunes and see that a product has a lot of stars, we think that's a great development, that consumers can directly review products. We think that's wonderful. I think of all of the times that I've bought clothing online and people have said, oh, this is a little small, order a size up, or this is a little big, order a size down, or the photo makes it look red, but it's really pink. I find that a wonderful benefit for consumers, if it's truthful. And our concern in this case is that it is illegal for the company, we believed, to post reviews about their own products without disclosing that they worked for the company. If a friend of mine says XYZ cookies taste delicious, that's one thing. I trust that. If XYZ says XYZ cookies are delicious, of course they're going to say that. So we think who is doing the talking is very important in this context. What our law now makes clear is that if there is a connection between the marketer of a product and an endorser, a blogger, a tweeter, that would affect how consumers evaluate or weigh the endorsement, that connection must be disclosed. That standard applies on Facebook, it applies on Twitter, it applies on all social media, it applies in blogs, it applies in regular advertising. Now, a lot of bloggers, now certainly it's a very useful tactic for companies to send free products to influential bloggers to have the consumer, to have the blogger write about the product. That's a fine thing. We are not looking for a fancy legal disclaimer. What we would like is for the blogger to say, XYZ company just sent me a free sample of their product to try, and here's what I think about it. And whether it is a favorable or an unfavorable review makes no difference to us. But if the blogger or tweeter or endorser got the product free, all we ask is that that fact be disclosed to consumers in a very informal, friendly, non-legal kind of way. The related area of this blurred lines phenomenon, and I'm sure I've seen this internationally, it's not new. Certainly one of the very first cases the FTC brought in 1917 dealt with what appeared to be a review about a vacuum cleaner, talking about how wonderful it was, when in fact it was printed by the vacuum cleaner company. So this is not a new phenomenon, but we're seeing it in different contexts. We called the phenomenon blurred lines, and we recently sponsored a national workshop on this subject. But we also have brought our first case dealing with this in its recent, in the recent way that companies do this. Now, as I said, the notion of what is, whether something is an advertisement or television programming has been around a long time. The FTC brought our first infomercial case in 1988. Infomercials are 30-minute ads that look to be, at first, a talk show or entertainment programming, when in fact they're selling the product. We're seeing it in a different way, though. A very popular morning program in the United States is the Today Show. The first 3 hours offer news and updates from the political world. The last hour is a little more fun. It has two very popular entertainers. Very often they drink wine while they have their show. It's fun, it's light, but they usually bring in guests talking about family issues or cooking issues or entertainment kind of issues. This example, as you can see, they brought in a guest who called herself the safety mom. And the safety mom recommended a certain kind of product. This was a home security system so that a parent could set it up and watch what was going on at their home when they were at work or away from home. You know, if their children were supposed to be home doing their homework, they could see the kids on the screen. It's a very helpful product. I can understand why people would buy it. And the safety mom said that she had recommended this product, she saw it, she liked it, she thought it was a wonderful product. What the safety mom did not disclose is that she received hundreds of thousands of dollars from the security company that sold the product. And that her job was to go on TV and to blog and to advertise about the product without it looking, from the FTC standpoint, like advertising. Our standard to the advertising industry, our basic rule is consumers have a right to know when they're being advertised to. We see that as a basic premise. It's perfectly fine. There's nothing illegal about the security company advertising their product in this fashion. But the FTC's concern is that consumers need to know. So our lawsuit was against the security company in this case. That raises a very controversial issue about the role of the media, the role of television. The FTC, out of concerns about being appropriate and of free speech considerations, in this case, has been very careful to direct its law enforcement to the advertiser, in this case, the security company. But I think we all see the issues that can rise about what the role of the media is in a situation like that. Let me shift very briefly to mobile marketing. Some of the cases that we're seeing in the mobile marketing arena are standard fraudulent or illegal practices that are simply being used in this new way. Here's an example. Consumers were playing Angry Birds. Come on, we all have played Angry Birds, waiting for an airplane or something. But consumers on their Android device got this warning: virus detected, and then click to remove. And it included a little green fellow. For those of you who are Android users, he may look a little bit like that fellow. In fact, there was no connection between the company sending out these warnings and the Android system at all. When consumers clicked to remove what they thought were viruses, what they got was this page: block mobile virus now, protect your Android today. But in very fine print, they found out from now until the end of time, they were going to be billed $10 a month for ringtones. There were no viruses. There was no scan for viruses. This was simply a method to bill consumers on their cell phones. So this is for us, part of what's new is that the smartphone is also the wallet. The smartphone is a way for business people to transact business without getting customers' credit card numbers or getting cash. Our concern is, do consumers understand that? That's how it's happened in a fraudulent setting. But there are a number of concerns, even with very major national and international companies. The FTC recently sued and settled a lawsuit against Apple. What we alleged was that for children's apps, these were apps for the youngest 3-year-olds, 4-year-olds, parents would have to put in their password to allow the child to use the Apple device to play. And these were with animated teddy bears and you know, these were definitely apps aimed at the youngest children. What Apple, however, did not tell parents was that once they put in their password, it opened up a 15-minute window where the child could buy in-app purchases without the parent's permission. In effect, setting a tab where kids could bill their parents' account without their permission. Now, of course, do parents need to be careful in using in their children using technology? Of course. And had Apple explained to consumers, if you let your 4-year-old play on this app, you are warned that you are authorizing that child to bill your account, maybe this case would be different. But you would be amazed at how, and anybody who's ever dealt with a 4-year-old knows they love to push buttons. On elevators, on computers, on television sets. Consumers were finding bills for thousands of dollars that their children had incurred without their knowledge or permission just by going like this. Apple settled this case. This is interesting because this was also the subject of a plaintiff's class action lawsuit, a private lawsuit, as well as a lawsuit filed by the Federal Trade Commission. We sued for a minimum of $32.5 million. We are currently in litigation with Amazon alleging similar violations. Amazon has not settled this case. Amazon is in litigation with us. Let me be fair to Amazon to say that Amazon disagrees with the FTC's position in the case. We will see what the judge says about that, but that case is pending. Another area we're seeing in the mobile advertising world is in the question of billing. We are also in active litigation against T-Mobile, the cell provider, alleging that T-Mobile allowed its service to be used by fraud or con artists who were billing people without their knowledge or permission for horoscopes or ringtones. Many consumers, thousands of consumers contacted both us and T-Mobile to say, I'm getting billed $9.99 for something and I don't even know what it is. I didn't okay this. The FTC, in those situations, basically the allegation is that T-Mobile allows those companies to use its billing system and then takes between 30% and 40% of the money. We do not allege, let me be fair, we do not allege that T-Mobile was illegally selling these ringtones, no. But our allegation was, at some point, when they had received thousands of complaints from their own consumers, they had an obligation to make these charges clear and upfront. The example that the FTC showed, it was, I think, on the 136th page of the bill and not very clearly announced. The issue of online disclosures, how to disclose this information on a smartphone, is very difficult, and we appreciate this. Let me finish just by mentioning that we have taken steps to provide guidance for businesses in this area. The most important one is when companies, if a disclosure is necessary under an FTC rule or guide, and it can't be made clearly on a smartphone, our advice for businesses, don't do it then. It is not a defense to say, the screen was too small. .com disclosures is a place to do that. Let me finish just by mentioning the issue of consumer privacy and data. Obviously, these are just some of the companies that the FTC has settled lawsuits against. One very recent case dealt with a company that sold a baby monitor, a similar product where parents could watch what was going on in the nursery from their office computer, let's say. The problem in this case is that the connection between the office computer and the monitor was not secure. And so anybody who knew how to find the place on the internet could watch what was going on. I'm not sure what the Spanish word for creepy is. That's creepy. It was ironic that the company called the software Secure View. That's an example of the kind of privacy consideration we have. Finally, when it comes to consumer education, we believe, let's face it, the best way to, prosecute fraud is to stop it from happening in the first place. We have to deal with businesses, of course, but there are also things we can do to educate consumers. Here's a very typical ad that we've all seen. This is a product called Fat Pho. Lose 10 pounds in a week. It's recommended by a doctor. So consumers click to order the product, but here's the page they get. I'm guilty. I wrote the Fat Pho ad with our colleagues in Canada. I am responsible for one deceptive internet ad. Somebody else is responsible for all the rest. What we're happy about that is that this had since it started many years ago, has had more than 1 million hits, which we hope result in more than 1 million educated consumers who won't be victim to scams like that. For businesses, we offer what we call our business center, business.ftc.gov. We have some materials and information you'll notice in the the lobby when you come in. Educational materials we have for consumers and business. One, for example, we have just issued in Spanish our first fotonovela. We have a fotonovela warning consumers, especially Spanish-speaking consumers, about government imposter scams. But you can go to business.ftc.gov. A major way we educate businesses is through our Business Center blog. I am shocked that the FTC has named me their blogger. I also suggest, if you have questions, to contact me directly at lfair@ftc.gov. I have my magnificent colleague, Michael Panzera, is here today. We have a great Office of International Affairs that looks forward to talking with you, to working with you. We have a lot we can learn from our brothers and sisters in consumer protection. We'd love to share ideas with you. For those of you who are attorneys with business in the United States, we'd like to talk to you too. It's been an honor to speak with you. Thank you very much.